Good morning, everyone, and welcome to the latest episode of PYA's Healthcare Regulatory Roundup webinar series. Today's topic is No Surprise Act, Real-World Impacts. PYA is happy to present today's webinar on this important topic. You may submit questions during the webinar by typing a message into the questions pane of the control panel. Also, immediately following the end of the webinar, you will be asked to complete a short survey and submit any additional questions. We will respond to the questions posed after the webinar by email. We have posted in the handouts pane of the control panel a PDF copy of the slides for your reference. Also, you will receive an email later today with a copy of the slides and a recording of this webinar. With that, I would like to introduce our presenters, Martie Ross and Kathy Reep.
Thank you, Laura. Good morning, everyone. Hey, thank you for joining us on this special occasion because today is the 2-year anniversary of the Healthcare Regulatory Roundup webinar series. Kathy, time flies when you're having fun. Hard to believe we've done this.
Make sure that everybody knows that the cookies will be delivered later this afternoon.
There you go. Yeah, it's hard to believe we've done this 48 times, but here we go again. And before we hit the main event, happy end of the PHE Eve, since tomorrow's the big day, the last day of the public health emergency. Our friends at HHS and CMS and DEA have been very busy the last 10 days to 2 weeks with some additional guidance, a few regs, temporary regs being published. So just FYI, we have updated the end of the PHE checklist. In fact, the latest version is today because yesterday evening about 5 o'clock, HHS published another guidance document. So we're all updated there. But enough on the PHE, please. Let's talk No Surprises Act. And I know I have a tendency to always want to start at the beginning, but I think the history of how NSA came to be is important because I think it is now coming back to haunt us in several of the challenges that we're going to discuss that we're facing as the provider community as we work through the NSA really have their genesis in the environment into which this law dropped. So before 2021, there were 33 states that had some version of surprise billing protections for state regulated plans. I mean, one of our issues we face whenever we regulate health plans is we have the state regulation of fully insured plans and federal regulation of self-funded plans under ERISA. And the states cannot impose regulations on self-funded plans such as surprise billing requirements. And so we had this real patchwork at best that predated the passage of the Consolidated Appropriations Act of 2021. That provision in that legislation that created the No Surprises Act was really the culmination of years of hearings in Washington on this issue. But what we ended up with was effectively 2 regulatory schemes under the single title of the No Surprises Act. The first being the prohibition on surprise billing, and in its place, creating a new payment methodology for providers who furnish services to patients whose network, they are out of network. They're not part of that insurance plan's network. So the idea is we're going to solve the problem of patients who, through no fault of their own, end up receiving services at an out-of-network facility. The other half of the legislation addressed the requirement to provide good faith estimates to self-pay patients to help them make decisions regarding where and when they receive services. The statutory scheme, remember this was passed in late December of 2020 with an effective date of January 1, 2022. So it was very accelerated in terms of the rulemaking process. And we started with the first regulations being published in July of 2021. We're talking 6 months prior to the effective date. We're getting the interim final rule, which addressed primarily the surprise billing and independent dispute resolution process. A couple of months later, we got a second interim final rule, which addressed these good faith estimates requirements. And then we'll also discuss today the August 22 interim final rule, which are changes to the IDR process as a result of litigation. So that's sort of the background on this process. Just for level setting purposes, remember, we're going to start with, in fact, we're going to spend about 90% of today on surprise billing. We'll catch up on good faith estimates and the notice requirements near the end. But for surprise billing, again, just to level set, the application of this is to healthcare entities, which is defined in the regulations as facilities. So hospitals, critical access hospitals, freestanding EDs, and ASCs. Providers, when they are furnishing services in facilities, it does not have application when they're in their practices in those settings. And then, of course, application to air ambulances, and promises soon that coming to a ground ambulance near you will be NSA rules for those providers as well. We're still waiting. Don't even have a rule over at OMB yet on that. These rules apply to commercial insurance. There are separate rules that are applicable to Medicare and Medicaid, and Medicare Advantage and Medicaid plans as well. But what we're concerned about here is commercial insurance, both group coverage and individual coverage. Kathy?
From the issue of the types of services where the No Surprises Act comes into play, first of all, we've got to separate emergency services, non-emergency services. So let's start with emergency services. The requirements under the No Surprises Act are going to apply to both the facility itself and the physicians or other providers providing services at that facility if the facility is out of network. If the facility is in network and emergency services are provided, then it is going to apply to those providers, physicians and other practitioners providing care at that in-network facility in the case of an emergency, as I said. When we start looking at the No Surprises Act, one of the really good provisions I think that was included in this was a fairly decent discussion of emergency services. First of all, when we talk emergency, we are using the prudent layperson definition or prudent layperson standard of what is an emergency. If the individual patient believes this is an emergency, then this law comes into play. The other thing that we always dealt with prior to the implementation of the No Surprises Act was patients who would present to an out-of-network emergency department need to be admitted, and the plan would indicate that they would cover the emergency service, but the patient should have been transferred to an in-network facility for the inpatient stay. Under the No Surprises Act, the way this has been drafted and implemented, any necessary post-stabilization services that were determined to be required by the treating physician have to be covered by that insurer, even though either the physician or the facility were out of network. If the patient cannot be moved using a non-medical means of transport, then the payer is going to have to continue to treat these services as a part of the emergency encounter. So that has been a major change.
And Kathy, it's important to note, even though we're talking about the NSA in the context of commercial insurance, when CMS finalized the Medicare Advantage final rule earlier this year, and they were discussing the obligation of MA plans to provide coverage, they effectively adopted the same definition for MA plans.
That's correct. So very important that we recognize the how extensive this has gotten. For the issue of non-emergency services, if the patient presents for non-emergency services at an out-of-network facility, the law does not apply, because the patient could have chosen to go to an in-network facility. But if the patient does present to an out-of-network facility, then we start to look at the providers, meaning physicians and other practitioners at that in-network facility. So in the case of those practitioners at the in-network facility, there is the opportunity for certain providers to have the patient sign a waiver that they can be balanced bill. This is assuming that the physician or other practitioner is out of network. But if the patient, well, I guess I would say the certain specialties cannot get a waiver. Under no circumstances can emergency medicine, anesthesia, pathology, radiology, neonatology get a waiver. They can never balance bill a patient, nor can your assistant surgeons, your hospitalists, those diagnostic services that are related to the care provided, they cannot be balance billed. And if there is any services that were provided by an out-of-network provider, when there are no in-network providers who can furnish the item or service, that also would preclude balance billing. I think the more times that Marty and I have talked about this, we pretty much feel that it's the surgeon only who could actually balance bill. So if a patient presents to an in-network facility, but the physician is out of network, most likely it is going to only be the surgeon who could actually get a waiver signed.
And only if they use the approved waiver format as well.
That's correct. That's correct.
So it's not just on the back of a napkin. It's got to be the form.
Absolutely. Clearly explaining to the patient their rights.
Yes.
Marty, what can we charge the patient?
Yeah, and again, this is our easing into the NSA requirements. The idea is you can no longer charge the patient who is out of network in the circumstances that Kathy described more than the in-network cost sharing amount. And of course you say to me, well, wait, how do I know what the in-network cost sharing amount would be because I'm out of network? And the NSA gives you 3 options depending on your location. If you are in Maryland, you utilize the all-payer rate system to determine the in-network rate. For 22 states, we have a specified state law in place prior to the NSA's passage that is used to determine what the in-network rate would be in these out-of-network circumstances. Now, this is not simply any rate you want to reference. This has to specifically be a rate established by the state for the purpose of calculating an in-network rate for an out-of-network patient. So don't rely on, for example, a workers' comp rate chart for these purposes. Also appreciate this is that issue of self-insured versus fully insured again, because the state law is only going to apply to our fully funded plans, not our self-funded plans. Those are subject to ERISA, not subject to state law. These state laws also vary in their terms of what types of services they cover. For example, of the 22 states, about half of them only address emergency services. They don't have these provisions with regard to providers, out-of-network providers furnishing non-emergency services in an in-network facility. They don't have those rules. So in those circumstances, the rates would not apply either. And then we just start raising this issue of, shall we say, choice of law, because it's not unusual where you have a circumstance where patient is from state A, provider is in state B, and the health plan is located in state C. So in those circumstances, which state law applies? And we're still working through figuring out those types of issues. That's one of these real world challenges that we're facing in the NSA implementation. If you are in a state that does not have a specified state law, or if it's a circumstance where the specified state law does not apply, then the NSA gives us the new solution, which is this qualifying payment amount, or the QPA, which is used for purposes of determining then what the patient's responsibility is, not what the payment to the provider is going to be, but what the charge that the provider can make to the patient. Okay. So how do we calculate QPAs?
And Marty, before you go over how to calculate, one thing I just want to let people know, your remittance advice now shows the QPA. That's not what we need. We need the QPA up front, ultimately, but we've got the requirements for plans to provide that QPA up front and for you to provide an estimated bill up front. That has been stalled, but recognize that you are getting the QPA for various services that you're billing for on your remit. It might be something to talk to whatever system you were using to post rates to start tracking QPAs for certain services. It might be good to track that by payer.
Because when I say, how do you calculate the QPA? You don't. It's the plan that calculates the QPA and provides that information to you. But it is a regulatory standard they have to follow in calculating that amount, which is based on what was their median contracted rate for same or similar service in the same geography as of January 31st, 2019, which then is adjusted for inflation on an annual basis. In the regulations, there are specific provisions on how a QPA is calculated for a new service for which there was not reimbursement back in January of 2019, or for a new plan that wasn't in existence in 2019 and thus didn't have rates for particular services at all. How you calculate the median is detailed here on the slide, but it is the methodology that the plan is supposed to utilize, comparing rates across multiple providers, identifying the midpoint, and then calculating the rate from that. There has, not surprisingly, been litigation around the methodology that CMS has specified in the regulations for calculating the QPA. That litigation was filed by the Texas Medical Association back in November of last year. We will come back to our friends at the TMA several times during today's presentation. As you note here in the parenthetical, we refer to this lawsuit as TMA 3, meaning there were two other lawsuits filed by TMA around the NSA previously. But this particular litigation is around the regulations regarding the QPA. The hearing on the summary judgment motions in this lawsuit were heard last month. We're expecting a decision anytime. But the specific issue raised here was ghost rates. The idea being that we have insurance companies that negotiate with multiple providers for rates. In some instances, the providers really care about rates, and so they'll negotiate aggressively. But for other rates, they don't care, because those are services they don't provide very often. So you end up with a rate schedule that is varied, right? So if I'm a anesthesiologist, I really care about certain rates, but I don't care about other rates for other services. So I don't negotiate aggressively, and those rates are lower. Those are referred to as ghost rates, where yes, they're on the fee schedule for that provider, but that provider rarely, if ever, performs that service. And so the argument in the TMA litigation is the QPA rates are too low as a result of that. There are also challenges with regard to the utilization, the term same or similar services. Again, the argument from TMA is that it's overly broad in the regulation as compared to the statutory language. We also have this issue of fee-for-service rates that are supplemented by some sort of risk sharing or bonus or penalty based on the provider's performance and how that's considered. The regulations say don't include that when calculating the QPA, and TMA argues, well, wait a second, the statute says it should be the total maximum payment that's utilized for purposes of calculating the TPA, and if you're excluding any of that value-based component of the reimbursement, that's not appropriate. And then finally, there's some issues around having TPAs calculate the QPAs for the plans they serve, and the inclusion of rates for other providers in their calculation of those rates, which again have that impact of artificially reducing the QPA rate. So this could be, we could blow the lid off all of this if the judge in the TMA litigation accepts these arguments on the summary judgment motion. So we could be back to, not ground zero, but pretty close in terms of QPA calculations. So stay tuned on this particular issue. As Kathy noted, the QPA shows up on your remittance advice along with the plan's proposed payment to the provider. So the QPA is on one line item, and then you're going to see the rate that the payer proposes to pay the provider. So what would be the plan's responsibility? They are responsible the payer is responsible for furnishing this information within 30 calendar days of receipt of a clean claim from the provider. You are, of course, familiar with the definition of clean claim, shall we say, and the obligations that plans often try to impose on providers to avoid determining the claim is clean. In addition to providing the QPA amount, the plan must also provide a certification of compliance with regulatory requirements in calculating the QPA. They have to disclose to you whether they downcoded the service. So if you billed, for example, for a 99213, and the plan says, yeah, no, this wasn't a 99213, we calculated this based on the 99212 instead, they have to disclose that to you. And in those circumstances, provide both the QPA for what you initially claimed as well as the downcoded claim as well. They have to include a notice regarding the initiation of the open negotiation period. We'll talk about that in a second. And the contact information for providing the contact information for who to contact if you intend to initiate an open negotiation period. Issue has arisen about providers complaining about plans' failure to provide the QPA or identifying issues with the amount listed for the QPA. The direction from the departments is for you to, as a provider, to contact the No Surprises Health Desk, and you see the phone number listed there, or you can submit a complaint via the CMS website. We'll talk about enforcement at the NSA, but really any of the complaints you have around the QPA are not decided through the independent dispute resolution process or the equivalent state process. They are instead compliance issues that are resolved by initiating a complaint through CMS and then their enforcement processes that CMS follows with regard to those complaints. If you are a provider not satisfied with the amount that the payer proposes to pay you on an out-of-network claim covered by the NSA, the NSA then provides for an open negotiation period that you may initiate within 30 business days of receipt of the proposed payment and the QPA from the plan. If the plan does not provide you with the required information or the required disclosures, so if they've dropped the ball in terms of their response to your claim, you may request an extension of that open negotiation period by emailing the email address you see here on the screen. So that's your remedy. If they drop the ball, you have to then request the extension to preserve your rights through the open negotiation period. To initiate the process, you send a notice to the plan that includes information regarding the claim and, importantly, an offer of what you believe is the appropriate out-of-network rate. Again, one of these kind of recent developments in the NSA world has been this publication of a standard open negotiation notice. You'll see there the website where that open negotiation notice is available. That is the expectation from the departments of what information you as the provider should be furnishing back to the plan when you initiate the open negotiation period. Again, you're not waiving your rights if you don't utilize the notice, but you are certainly preserving your rights if you do. So in deference to that presumption, you want to utilize the form. If you send the notice and there is no resolution after 30 business days, you then have the option of pursuing a formal dispute resolution. This includes if you send the request for an open negotiation period and you never again hear from the plan, which apparently is not that uncommon, you are still counting that 30 business days from when you send the open negotiation notice to then initiate the formal dispute process. Now, what that formal dispute process is depends. Again, right. This goes back to that issue is if we drop the NSA into a pre-existing state statutory processes. So Whether you at this point pursue the federal process or the state process, again, depends on where you're at. So up to this point, the federal rules regarding the provision of the QPA and the open negotiation process apply across the board. It's when you reach the end of that open negotiation process that you then decide whether I'm going to go through the state process or the federal process. Okay? And most likely, if you're in a state where the state process would apply, it would be not necessarily disqualifying to the state process if you fail to utilize those remedies in the federal process, right? Now, it's very clear that if you go to the federal independent dispute resolution process, you have to have gone through the open negotiation process first, or that claim is not eligible, and you have to meet the timelines for the claim is not eligible. That's not necessarily true if your remedy is actually through the state process. Some states will have required and will meet the open negotiation process, but some will not. So that's, again, unique circumstances to your particular state. The IDR process is always going to apply when you're dealing with the self-funded plan or the federal employees health benefit plans, except you see 5, 6 states listed there where the state law that created a process for the resolution of these claims permitted self-funded plans to opt in. So yes, it's mandatory for fully insured plans that you utilize the state process, but in these states, there's a provision in the law that permits self-funded plans to opt in, and thus, when the federal IDR process was created, those plans in these states have the option saying either we're going to follow the state process for this plan or we're going to follow the federal process, and it's a singular election.
So a provider is going to have to determine whether or not a particular plan within their state, let's say in Georgia, has opted in or not.
Exactly. To know whether you go to the federal or the state process, that's obviously a practical challenge. And so the best solution we have at this point is to go, if you were a provider, go both ways. So preserve your rights under the federal IDR process by initiating that process, but also pursue the state process as well.
However, you got the fee.
Right, exactly.
We'll get to that in a minute.
We'll get to that in just a second.
Yeah.
Exactly. And no chance for a refund of that fee as well. There are then there are then states where there is an existing state process, but it is again only available for fully insured plans, and you see the list there on the slide. Now again, we get the same issue, is that some state laws only apply to emergency services, and so they don't have this coverage for non-emergency services furnished in a facility by an out-of-network provider. In those instances, because the state process doesn't exist, even though if you're in a state that has a state process, either you're going to find yourself going to federal IDR, either because you're dealing with a self-funded plan, or you're dealing with a federal employees health benefit plan, or you're dealing with a fully funded plan that's subject to the state process, but the particular claim is not. And so in that circumstance, you go to the federal IDR process for those. And again, we run into this issue, what state law apply? Where the provider is, where the patient is, or where the plan is? I think the answer to that is where the plan is, because that is the regulated entity for purposes of these processes. But I don't think that's a definitive answer. And I think that is part of the challenges, these growing pains we're going through in these IDR processes, is figuring out which law applies. Kathy?
When you look at the process from the IDR, for filing an IDR, there are a number of steps that you must follow. The thing that is really important, and I think the most difficult one, is that if you have a failed open negotiation, then you are going to send a notice of IDR initiation to the various departments at the website that's shown on the slide within 4 business days of that failed negotiation. So you've got that 30-day period for the negotiation. Now you've got 4 days, 4 business days to actually file the negotiation. And I'm going to raise an issue with that momentarily when we talk about money. There will be the non-initiating party. I'm just going to assume or say that the initiating party is the provider, either a facility or a physician. The non-initiating party would be the insurance company in that case. Within 3 business days of the IDR initiation date, then the non-initiating party is either going to have to agree or disagree, object to the preferred entity to do the IDR, make the determination. So while the initiating party is going to essentially select who they want to have do the dispute resolution, the non-initiating party has the opportunity to object to that or to agree. Then you're going to have the initiating party again. In my scenario, this would be the provider. Notifies the departments of the selection of the dispute resolution entity or the failure to agree if the non-initiating party disagrees. That takes 4 days. Finally, we have a selection of the IDR entity and the process starts. There is a fee that has to be paid within 10 days of the date of the selection of the independent dispute resolution entity. When we began this process, the fee was $50. It is now $350. Significant jump in the amount that you're going to have to file. And if you are actually doing a batch, a number of claims being submitted at one time for the same or similar services, then that fee would actually go higher. It could be as much as $700. The thing that is important to address here, we're going to talk in a minute about what is a claim. And remember that $350 administrative fee for the claim that you are disputing. And if you do not pay the fees, that administrative fee is due from both of the parties, both the initiating and the non-initiating provider. If you fail to pay that fee, then the independent dispute resolution entity is going to accept the payment offer that was presented by the party that did pay. I want to address the issue of paying the fee, and it is how do we move forward. In a physician's office, it perhaps is an easier process to get that $350 paid. I'm not sure how easy it is in a hospital to actually file a dispute and to promptly get that $350 paid. It's a process that I think has to be set up very clearly in terms of who has the authority to move forward and the process for actually making that payment and making it timely. Within 30 days of all of this happening, the IDR entity is going to issue an opinion, and they are either going to accept the QPA or the amount proposed by the not by the payer, or accept the requested payment amount presented by the provider. If the whoever, I guess I would say, payment has to be made to the provider within 30 days. We're going to talk about that one because it's not really happening. And the cider fee is going to be returned to the prevailing party. This is not that initial administrative fee. This is actually going to be the cider fee that is going to vary based upon the extent of the dispute that is being filed. And then there is what we call a cooling off period, where you cannot submit an additional notice of IDR initiation involving the same party for the same type of service, and that is for a 90-day period. All of the information on the IDR process and batching claims was made available in August of 2022, and there is a link there that outlines the process. Marty, I think on the next slide, we showed the actual standard notice for the IDR initiation. You can see the level of detail that is included in this.
Yeah, and this is new. This is one of these new things, right? Because the department's added this standard notice because of and we'll discuss this issue of ineligible claims in the IDR process. And their theory is if we capture more of this information at the beginning, that we'll be able to resolve those eligibility issues before it continues to clog down the process. So their solution has been, the process is broken, we'll put a greater burden on providers when they initiate the process to solve the problem. And in many circumstances, you're just not going to know the answer to these questions. Like, will you know if it's a fully insured or self-funded plan when you're submitting the IDR litigation? It may be that you may want to do some of this discovery as part of the open negotiation period, so that if it reaches the point you do have to initiate the IDR process, you'll be able to complete the standard notice for it.
I would think also, go back again, Marty, I think for some providers, when you're dealing with the same large employers within a market, this is information that you might want to begin collecting right now so that you have it in the case of future disputes.
Appreciating that they'd love to change employers, change plans on a regular basis.
Oh, I know, but
I
think it might be one of those things that you do, you kind of keep an eye, keep some
Yes.
basic information on file.
Right.
There has been, let's talk about TMA4. Marty did TMA3. We're working backwards, I think, on this whole thing about the Texas Medical Association. But TMA4 was essentially when the decision was made to increase the fee from $50 to $350. That's a 600% increase. And the reason, the justification that was given for this increase was due to supplemental data analysis and increasing expenditures and carrying out the federal IDR process. That was the rationale that was given when they increased the fee. Texas Medical Association, in filing their challenge at the end of January, said that that increase in the fee effectively closes the door to IDR for many out-of-network physicians with small value claims, threatening the viability of their practices and ultimately placing patient health at risk. You got to remember, what is a claim? It is the same or similar service. You can get very granular on this, and we'll show an example of the granularity of it, because it's not, I had an emergency room encounter where there was a laceration and I repaired the laceration with sutures. All of those are different services. So recognize that in many instances, we're talking about one claim that as a provider you would file a 1500 claim form. There are multiple services included on that claim. So the lawsuit challenges the issue of batching because the statute says that you can batch if the services are related to the treatment of a similar condition. Regulation says same or similar services, and as an example, if each is billed under the same service code. Well, my example of that E&M service, I've got an evaluation and management service, I've got the repair of the laceration, I've got the sutures themselves, the cost for the medical supplies. I'm dealing with different services and different codes. So am I now paying for this one claim $350 times 3 to get this dispute filed? Marty and I we've threatened to play the recording of Secretary Becerra. There was a hearing back in March with the Senate Finance Committee, and the question that was asked is why there is such a backlog in the decision making for the IDR, the disputes that have been filed. And he said, and this is a quote, "What we're finding is that there are way too many claims in the IDR process that too many of the claims are frivolous because there's no cost to file a claim.
Oh, really?
$350 per, but there's no cost to file. So, and that what providers and the parties who are disputing the payments that they received, what they're doing is filing frivolous claims. So not real comfortable with that statement.
Yeah, and Kathy, really, there's been a couple of articles that have been coming out here in the last month that this is a hot button issue in Washington. There are several senators and representatives that are well aware of the dysfunction within the IDR process. We're proposing different legislative solutions, but definitely HHS is on the hot seat. Apparently, Becerra walked back this claim subsequently. I couldn't find any reporting of any walk back, but it's pretty stunning when you watch this video going, wait, there's no cost to file these claims. You just increased it to $600 and because of your budget. That you said that was necessary.
600%.
600%,
I
sorry.
do hope that the hearing with TMA 4, when it's heard, would actually include the replay of Secretary Becerra.
Yeah, not that we're bitter or anything, right?
No, we care about our providers.
There we go.
Okay, year one of the IDR process. It's hard to believe that we are celebrating year one, but between April of 22 and the end of March 31, there were over 334,000 disputes initiated through the federal IDR portal. That's significantly higher than the number that was expected. I'm sure that it's because there's no charge. No, wait. 14 times higher than the number that was expected for the first year of the program. The non-initiating party, go back to my scenario where most likely the initiating party is the provider. The non-initiating party, i.e. then the payer, has challenged about 37% of the claims, saying that they were not actually eligible for the IDR process. The reason for that, a variety of reasons, whether it be you didn't go through the state process or you never opened negotiation or whatever, but recognize that the eligibility of about almost 40% of the claims were challenged by the initiating party. Currently, as of the end of March, again, less than a third of the remaining disputes have actually been settled. 40% of those, the payment, well, 40% of the claims had a payment determination made. So again, out of the 106,000, only 42,000 actually had a payment determination made. But in 71% of the cases, it is the initiating party who won. Again, I would think most likely we are dealing with the initiating party being the provider. I am not sure, Marty, that we're going to see payers being initiating parties. It was determined that about, again, close to 40% of the disputes were not eligible for the federal IDR process, should have gone through a state process. And then there are other reasons that about a third, again, about 25% of the claims were closed. Either the fees were not paid, the parties reached a settlement outside of the IDR process, but you can see that there are a lot of claims out there still waiting to be resolved. As the rules keep changing because of further litigation on this, we keep stopping and starting, I guess is the main thing to say through this process. So Marty, you want to talk a little bit about the issues of eligibility?
Yeah, and you got to think that if we've got that many claims that are stuck in the process, that aren't reaching payment determinations, aren't getting settled, it's because there's an issue around eligibility. And it's not just those cases in which the payer asserts that the claim is not eligible, it's also the review by the cider, and the cider determining whether it's appropriate to adjudicate the claim. There's a whole bunch of reasons that could happen. I think number one is federal versus state. Should this claim have been brought instead through the state process as opposed to the federal process? I think there are a lot of issues around batching and bundling of claims, as Kathy's discussed. Certainly compliance with the applicable time periods. There are disputes about when did the open negotiation period initiate, when did it end, was the claim filed within the appropriate period of time. Again, the CIDR's got to work their way through those issues. And then there's also issues of whether we actually completed the open negotiation period. So you may have questions of whether the plan claims it never received notice from the payer of the open negotiation period. Specifically, in addition to the report that Kathy was drawing from for the numbers she discussed, we also had published recently the formal Q4 of 22 report. It shows us that the non-disputing parties during that quarter were challenging about 40% of the disputes. So the payers have now figured out they can slow this process down by challenging the eligibility of the claim through the federal IDR process. And similarly, of the disputes that are closed during the quarter, 64% of those were having been determined to be ineligible. So it's accelerating, right? So the number of claims going into the process, CIDRs are kicking more of them out based on ineligibility. And really, what's their incentive? Because they're still getting paid. The administrative fee is getting paid if the eligibility determination isn't made. So there's a process here that has incentives working at cross purposes to actually getting these matters resolved for providers.
So again, if I went to the CIDR and it was inappropriate, I've paid my $350, I don't get my $350 back.
I don't believe so.
Thank you.
No. Now the CIDR doesn't get paid. You don't have to pay. You wouldn't have got to the
point.
point.
You don't pay the administrative fee, but you pay the administrative fee, but not the actual
CIDR fee. Again, and that may depend on the point in the process where ineligibility becomes an issue, because you pay the fee. The fee is paid when you file your briefings, and so it's made to be a process determination of when the CIDR determines that the claim was ineligible.
Right.
It's just, again, there's just not a firm process of when these different decisions have to be made by the CIDR with regard to eligibility. Appreciating this issue was significant. The departments in November 22 began using contractors and other government staff to help the CIDRs go through these pre-eligibility reviews. That's when they added the standard format as well to ensure that you're capturing the information needed to resolve these eligibility issues.
We wanted to provide throughout this presentation a couple of real life scenarios that we have actually seen or heard. And so this is the first one. The CIDR gave an emergency department physician 48 hours to provide the DRG for the service in dispute. Well, first of all, we all know that the ED physician, this service was provided in the emergency department. There was no admission involved, but also DRGs don't apply to the physician claim. But the CIDR reached out and said, we need to know what DRG you're disputing, and gave him 48 hours. The physician responded that this was an ED-only claim, that there was no admission, and the CIDR then replied that a dispute must be resubmitted to dispute every CPT or claim line separately, $350 per service code disputed. We mentioned earlier that the TMA litigation that has TMA 4, I believe it is, that addresses the issue of batching, where the regulations allow only services billed under the same code. TMA is saying a single radiology encounter between one radiologist and one patient can lead to a half a dozen or more different claims, all of which must be submitted and reviewed separately in IDR, and on top of that, paid for each one of those that $350 administrative fee. So again, is the repair of a laceration a single claim or multiple claims? From a Marty?
So Kathy, let's switch gears from sort of the procedural issues we've been talking about to actually the substantive work to be done by the CIDR, right? So how does the CIDR decide what the appropriate out-of-network payment rate should be? What should it require the plan to pay the provider? The statute itself, that's the starting point. It directs the CIDR to consider the qualifying payment amount and then consider other information that's submitted by the parties. You see here the detail as to those other relevant considerations. What's not relevant, of course, is Medicare and Medicaid payment rates, nor customary charges from the providers. So that's our starting point. That's what the statute says. The issue now is how did the departments interpret the statute in creating the regulations that direct how the CIDR review this. That becomes TMA 1. So we finally get back to the original TMA lawsuit. So this is filed in October of 22. So, excuse me, this lawsuit is focused around the July 21 interim final rule. And it says, that rule said the CIDRs should treat the QPA as the rebuttable presumption of the appropriate payment amount. And so whatever offer, either the plans or the providers offer that's closest to the QPA should be the final determination by the CIDR. So it's almost automatic, right? The CIDR is just going to say, well, the QPA is $100, the plan offers $95, the provider says they want 110. In those circumstances, we're going to go with the 95 because that's the one that's closer to the QPA. The court didn't like that. The court in Texas agreed with TMA and it threw out the rule saying it was contrary to the clear statutory language. That decision that comes down in February of 2022, I've got the dates wrong. This also was filed in 10 of 21. I apologize for that. The district court hands down its decision in February of 22. That's what results in the August 22 rule, the interim final rule, which revised the criteria to be applied by the CIDR in determining what the appropriate QPA is. And in that circumstance, they tell them to consider the QPA and then other information that is relevant as identified in the statute, but make sure you don't double count those items that were already considered in determining what the QPA was. That interim final rule also requires the CIDR to provide a written payment determination. So explain why they did what they did. That was also a new element in 2022.
On that double counting issue, if you were a teaching hospital and one of the reasons you asked for an increased amount of money was because you're a teaching hospital, but there was another teaching hospitals in your market and therefore their rate was included in that QPA, it would be considered double counting because you can't claim that you should get more as a teaching hospital if there's already a teaching hospital in that mix. So that's one of the ways that this one just did not work.
Right. So that brings us full circle to Texas Medical Association 2. This is the lawsuit filed in response to the August 22 interim final rule. And again, TMA said this rule is too deferential to the QPA. You're effectively making the QPA the out-of-network rate, which is problematic because it's a median rate, meaning half of the providers are being paid more, half the providers are being paid less. And the whole intent Congress had in creating this process, the CIDR process, was to avoid creating a national out-of-network rate. And the judge agreed, issuing a decision in February of this year, saying that the process puts the thumb on the scale in favor of the insurers and directed that the offending regulations be stricken and that in fact CIDR should be directed to follow the statutory language. HHS is not rolling over this time. They have appealed the decision, so they didn't publish a new final rule in response to this decision. They're actually challenging the appeal. That leaves us then, of course, so what rules should the CIDRs apply? And you end up with this mess. CMS in March published this series of guidance on what applies when. And you see that there are 3 separate documents, two from October of last year, one then from March of this year, which detail the standards the CIDRs are to apply depending on when the services were provided. And so if you are in fact pursuing a claim through the federal independent dispute resolution process, be sure that you are referencing the standards that are applicable to your claim as detailed in these guidance documents, because that's the rules the CIDR are to apply, and certainly they are more favorable the later you go when the service was provided.
Thanks to TMA.
Exactly.
when we look at the reports that have been published by CMS related to the disputes that have been filed, obviously emergency department services lead the way in terms of the number of disputes that have been filed. Significantly more than any of the other service lines, almost 120,000 disputes filed by emergency room services. And this would be the physician. This would not be the hospital. Hospital would fall under hospital outpatient services, which are not even on the list.
Yeah, right. I couldn't find data on the hospital, the number of hospital claims filed. These are all the CPT, the physician services. That's what's included in these reports that have been published.
That's who's filing. That's where the filing is happening. Now, before we go to the next slide, everybody mentally think about claims by payer. What particular payer has had the greatest number of disputes filed against it? Hold that in your mind. Go to the next slide, Marty. And you can determine whether or not you were correct. United Healthcare has the greatest number of disputes that have been filed, almost twice as many as the second party.
And Kathy, more than all the blues added together too.
Yeah, that's true. All the blues added together do not meet United Healthcare. From a payer negotiations issue, and we started seeing this early on with the NSA in terms of providers being asked to take a lower rate or else be considered out of network. The payers are not as engaged in terms of having everyone in their network. If you're not in network, then we're going to be dealing with what you get paid and whether or not you're going to be taking it to arbitration. The payers are beginning to target in-network hospital-based providers such as anesthesia, radiology, to reduce the contracted rates or face being considered out of network. And what happens is as these providers go out of network, then the QPA is going to go down. So it does become an issue, and we wind up having, for those who remain in network, the QPA has gone down because the guys with the higher contracted rates are no longer considered in network. And on the issue of staffing companies, there were a number of staffing companies that actually opted not to go into contract with certain payers because of the issue of what they could get as an out-of-network provider. So we're not sure where this is going to take us, and what the hospitals that have contracted with these staffing companies, what are we going to be dealing with there in terms of rates? Marty, did you have more on that particular issue?
Yeah, I think what's going to happen is that they're going to come to you with their hands out saying, well, we're being paid less by the payers, but our costs are the same. So if you hospital want coverage for your ER, radiology, anesthesiology, lab, whatever, you're going to be paid more to the staffing company out of pocket. So
and that's probably
right
going
there
to
in
be
your
the
face.
staffing company and any contracted provider that you have.
Yeah, absolutely. This is definitely going to lead to more demands for the hospital to pay more dollars to the physicians. So very briefly on enforcement, it's a very interesting federal-state partnership because the initial investigation of a complaint in many instances falls to the state agency. That's when you see that those dark blue squares here. But again, it's going to vary by state depending on whether the state had a pre-existing surprise billing legislation. Enforcement is starting, and don't be the least bit surprised. Kathy's going to tell you quickly a story about an enforcement action that was initiated involving a hospital-based physician who was not employed by the hospital. That's an important note.
This anesthesiologist, not hospital-based, not employed, by mistake, I'm sure, balance billed a patient who had come in through the emergency department, had a surgical procedure. Anesthesiologist balance billed the patient. The hospital, to the CFO and the compliance officer, received a request from the CMS Center for Consumer Information and Insurance Oversight. And the wording on this for the hospital, let me just skip to the last bullet because of time. Provide documentation that demonstrates, this is within 10 days of the date of this letter, Provide documentation that demonstrates the extent of compliance with the requirements of the balanced billing in cases of emergency services statute, specifically the results of an impact analysis to determine how many individuals received emergency services from the hospital since January 1 of 2022 to the present and were billed amounts in excess of their in-network cost sharing amount as reflected on the payer remittance advice. This is asking the hospital to do this related to the data that the patients that they have seen, has nothing to do with the anesthesiologist, who is the one who balance billed.
Yeah. So not only are we having issues with the process in the IDR, we're having issues with the enforcement activity pursued by the departments as well as the states. Very briefly on good faith estimates, there's not much going on here. Ever since CMS announced we're not going to require you to include your co-provider. So when you're doing GFEs, you're only including your own information. I think the interesting issue right now for GFEs is there's trouble brewing. When you provide an individual who says I'm self-pay and you provide them a discounted self-pay rate, but then that ends up being less than what their co-insurance would be if they submitted the claim to insurance. And so
they said they were self-pay, although they are not
right.
really.
And they're not really, they submit the claim, their co-insurance ends up being more than their discounted self-pay rate, particularly an issue if you've got high deductible health plans. How are hospitals going to resolve those disputes and not end up with egg on their face with these providers? You have here on the slide the notice requirements just as a reminder. That yes, this is one of the ways that the agencies are identifying targets for enforcement activity. So ensure that you've crossed your T's and dotted your I's on enforcement activity. And finally, even though we're a little after the hour, we will not be here for the next regulatory roundup on May 24. Our colleague Susan Thomas, who is a HIPAA whiz, is going to be talking about the new proposed HIPAA regulations that are coming online. So we hope you'll be able to join them then. So thanks for today. Appreciate you. Have a good one.
See you in June.
Thank you. And thanks to our presenters, Martie Ross and Kathy Reep. Later today, you will receive an email with their contact information and a recording of the webinar. Also, the slides and recordings for every episode of PYA's Healthcare Regulatory Roundup series are available on the Insights page of PYA's website, pyapc.com. While at our website, you may register for other PYA webinars and learn more about the full range of services offered by PYA. Please remember to stay on the line once the webinar disconnects to complete a short survey and post any questions you may have. On behalf of PYA, thank you for joining us and have a great rest of your day.